Hello, hello. Hello.
Hello, ma'am. Hello, ma'am. Good morning, ma'am.
Good morning. I think I was in another seminar, international seminar.
Oh, so shall we start,
I'm
ma'am?
going to try to go ahead.
Okay, ma'am. You were saying something?
I'm trying to share my screen.
Ma'am, if you see below, you will get a bar. There is an option for present now. If you present
Okay.
now, then your whole screen will be presented, and then you can open your app, your PowerPoint presentation, and we will be able to see it. Can you see a present now button below?
Can you see it now?
Not yet, ma'am. Did you press the present now button, ma'am?
I did. I did.
Okay, just give me a moment. Let me see if I can do it from my side.
Can you see now?
1 second, ma'am.
Yes, we can see it.
Oh, great. Thank you.
Yes, we can see it, ma'am.
Perfect. So would you like me to go ahead and get started?
Let me give the welcome address. Then, ma'am, you can start.
All right.
Okay. Respected seniors, my dear friends and colleagues, and my beloved student and participant. With utmost pride and privilege, I introduce our speaker, Ms. Kristi Harrington. Ms. Kristi Harrington retired as a judge after serving 2 terms in the South Carolina Circuit Court. After her retirement, she is now a South Carolina Supreme Court certified arbitrator and negotiator. She is also a visiting professor in University of Charleston, USA. I had the privilege of hearing her about a month ago in a seminar conducted by MNLU Mumbai and contacted her. And she has agreed and took out some time from her busy schedule for our students from Assam. I am very deeply honored by this. My lady, it is indeed a pleasure to have you amongst us, especially when our remoteness doesn't allow much international exposure. Our students hardly get such an opportunity, and therefore I thank you from the core of my heart. As we know, the recent COVID pandemic has forced us to adapt to the changes and proved that we need to adapt to the changes or perish. The field of law and adjudication has also seen certain changes to the online medium, about which our speaker is going to talk to us today. So, without much ado, I give the mic to our speaker. Ma'am, you may proceed, ma'am.
Thank you. Thank you so much. And it is a pleasure to be here. It is bright and sunny early morning in South Carolina. I know it is evening time for y'all. So thank you for staying and giving me some of your time this evening. So, very good point. We've all had to adapt to change. COVID has touched everyone globally in some capacity, some more than others. And we in the legal profession around the world know that we have to change and adapt in this post-COVID-19 world. So I like to share, and I don't know where. My pictures did not translate. Oh, I'm so sorry. So I went to the High Court in India and had a lovely visit, and I just wanted to share those pictures with you. So I'm very sorry those did not somehow come through. So we'll move on. I am from Charleston, South Carolina, and that is on the East Coast of the United States. I teach at the Charleston School of Law. I retired from the bench, and what I teach at the Charleston School of Law is a trial advocacy class, and I teach some negotiation skills. What we're going to talk today is about COVID's impact on the U.S. judicial system. What we saw was immediately in the spring was the immediate closure of the court, any discontinuation of jury trials, and then we began this increased use of technology. The United States, our legal system in particular, was hesitant and has always been hesitant to incorporate technology in trials. We're worried always about the defendant's constitutional rights, the right in Sixth Amendment for confrontation, and really concerned about privacy and hacking issues. And so when COVID hit and we had to close our courts, most court systems just thought, well, let's adopt this wait and see. And no one really immediately began to pivot to incorporate use of Zoom or WebEx or Google Meet. What that happened was we realized that there were some things that we needed to worry about. And we have this immediate where you have a right in civil cases in the United States to a jury trial. And so cases stopped. We knew that bond was entitled for certain defendants, and the criminal cases, we were continuing to have bond via video and some guilty plea settings, but really our civil courts shut down because there was not the necessity for right to speedy trial. What we did realize was the U.S. Constitution allows jury trials for civil cases, and this is our Seventh Amendment, where the value in controversy shall exceed $20. And so we may not think $20 is a lot, but our Constitution does guarantee that. And it was a significant sum when the Constitution was written. One of my things that I learned during my first trip to India in the history of your jury trial system. And so I find the comparison between India's justice system in the United States very interesting. And so I've done some comparisons on jury trials. So what was an immediate closure of the court system. And then there were some positive outcomes. And I think most of us will, of course, agree that the COVID and it has had very negative outcomes, causing worldwide numerous deaths and illness. But there are some bright sides, and that's what we're going to talk about today. So when we realized that we weren't going to immediately be able to open our court system, courts began to reluctantly use WebEx or Zoom. I personally am on the judicial panel for the American Arbitration Association, and their preference is to use Zoom. So I have also used Zoom in my personal mediation practice, and when I teach remotely, I do use Zoom. My court system here in South Carolina does prefer WebEx, and when I teach at the National Judicial College in the United States, they also use WebEx. So those are our two main platforms, which is, apologize for not being as proficient on Google Meet. So we then returned to mediation and arbitration because we realized people were not going to get their day in court. The mediation and arbitration aspects became very expeditious tools for us to resolve disputes. Most states have some sort of mandatory mediation required in their civil justice system. Mediation is mandatory and compelled in certain types of cases, not all cases. So we're going to spend some time today talking about which the common types of ADR. So what we utilize a lot in South Carolina and around the country is what we call early neutral evaluation. And really what that does is parties involved in a civil dispute, the attorneys will call a mediator or even an arbitrator and give them the facts of the case, and the neutral will evaluate based upon trends in that area. So this is a good way for the plaintiffs, the wronged individual, to be aware and begin to evaluate their position for reasonableness as to the request for damages. Pre-suit negotiation is commonly used in our system in South Carolina, particularly for medical malpractice cases. So if a doctor has performed a surgery incorrectly, or there was a negative outcome for the patient, then the statutes, the law requires that there be negotiation before the lawsuit is even filed. So it's nice to have a mediator come in and talk to the counsel, the attorneys involved, before the lawsuit is even filed. That does help the flow and the management of the case. And a lot of times the cases are not resolved at that point, typically because they're still very early in the discovery, the fact gathering stage. But this also gives the plaintiff an opportunity to learn who is involved in the case, because typically if a surgery did not go as anticipated, there will be a hospital involved, typically a nurse, a doctor, an anesthesiologist. There will be several defendants named. And so this pre-suit negotiation allows some interaction between all of the parties before the lawsuit is filed. The two common ones that we'll talk about and spend the most time today are mediation and arbitration. So what's the benefit of mediation, and why do we now believe, and in the United States have really pushed mediation. I really, even with all of my backgrounds, have tried hundreds of cases as an attorney and sat and presided over hundreds of cases as a judge, believe that mediation is a really useful and powerful tool. It allows the parties to control the outcome of the case. Once the case goes to a jury or to a judge, the power and the options are limited in a civil case. It is typically only a outcome, a reward of damages of money. In mediation, there can be a wide variety of outcomes. And so these are the top 5 reasons that I believe that mediation is really useful and really we should look to mediation before litigation. It empowers the parties. You have a neutral, impartial or mediator. You have principal negotiations. The settlement is voluntary and it brings this collaborative problem solving concept. So how do we give the power back to the parties? So in a typical litigation setting, the judge is assigned by random choices or just necessarily by the fact that that may be the only judge in that jurisdiction. Allowing the parties to choose their mediator, somebody perhaps that they know will have good rapport with both the plaintiff and the defendant, or has an extensive background in either the subject matter of the litigation, really gives some power back to the parties as they're able to make some determinations. A lot of times, the court may appoint a mediator. There may be a list of 3 mediators that are sent out, and the parties agree on one. And so, this being able to select the person who is going to help you resolve your matter really starts this process off nicely for the parties. You're getting to choose where you go. If you file your lawsuit in South Carolina, you will typically file the lawsuit where the defendant resides, even if that's a defendant corporation. So let's say that your plaintiff lives in a different location than your defendant. Maybe you want to do the mediation closer to the plaintiff, or maybe you want to do it in a neutral area. Mediation gives you lots of flexibility in choosing the forum. And again, as I indicated, you get to choose your settlement. You can structure it in any way. So all of these things help give power back to the parties. The voluntariness of the settlement really helps go and helps the parties craft what type of resolution they're going to receive. You can do unconventional compromises, and sometimes an injured party only wants an apology, something that a traditional court setting can't give them. Maybe there's some sort of payment plan or something like that you can work out in mediation that you would not be able to in a traditional litigation. All of the issues can be addressed. And so sometimes when in a court system, if in a setting, if you haven't listed all the claims against a particular individual, those would not be addressed in the jury trial. Or maybe they're not ripe yet. Maybe they're not able to be heard in that particular forum. But all of those things can be talked about and addressed in mediation. So again, that's what makes mediation a really wonderful way. So why are attorneys and parties in the United States so hesitant to use mediation, particularly in the last few months. As you know, um, lawyers tend to not like change, especially in the United States. So this technology was new. Uh, Early on, there were stories about Zoom bombing and people hacking in, and there were concerns among attorneys as to privacy issues and confidentiality, attorney-client privilege issues. And so this new technology, along with unfamiliar procedures, really at the beginning of COVID caused most attorneys to just say, let's just wait and see what's going to happen. The courts have to open up soon. Well, it is October 9th in Charleston, South Carolina, and we have yet to have a jury trial since March of 2020. So we're now in our ninth month moving forward of no jury trials. So the council now realizes you know, you don't know who's in front of me right now or behind me. Anyone can be sitting outside of the screenshot, and that could, again, potentially affect the confidentiality of the process because your client um, may be held to confidential statements. They may have signed a waiver and an agreement not to discuss what happens in a mediation, but what about the individual that is sitting in their room with them? Or what if the attorney's um, secretary or a legal assistant walks into the room? Are you going to make them sign the same confidentiality waiver? So those were all concerns and still continue to be concerns. How do you control your client? Again, what is your client going to be paying attention during the process? We all know, I've done it and I assume others do, is you've got a webinar going on, maybe you're checking your emails, checking your phone, um, taking a bite to eat, something like that, and you're not fully focused on what's happening in front of you. So we're worried about client control. Also worried about it's easier when you have your client sitting right next to you, to the left or the right, in the office, that you can interject as needed or ask your client to step out if they're getting too emotional, too upset, if they're crying. But if you are in a separate, if you're all appearing via Zoom, it's hard to control your client that way. Um, and most people felt that this technology was not going to be as effective. So the new technology was the biggest issue, and now I find that using the technology is just as effective. I have had just as good success with mediations on Zoom as I have in person. And so, how do we do that? How do we gain over all of these things that I just said was a problem? It is important that we as counsel, we as lawyers, law students involved in the process, become as familiar with the technology as we can. There's always going to be glitches, and I have put together hundreds of PowerPoints, and I don't know what happened to my pictures. So having procedures that you're unfamiliar with, being comfortable with this technology will help facilitate this process. Being able to control your client, and I think what a good mediator would do is be aware of any issues that are going to arise. So the client, there's a multitude of ways. In Zoom, I utilize breakout rooms. And prior to the mediation, I set up breakout rooms for all of the And then I do a separate breakout room for counsel. So if I speak to counsel privately outside the presence of their clients, I can put them in their own breakout room. I can come and I can discuss with them some of the issues um, outside the presence of their client. If I feel that the client is not listening or not paying attention, then we can address those things as they come. I also find that having a run through, a technology run through, especially with clients who is not as familiar with Zoom, and I know most of you probably are like I am. We typically have one or two, if not more, Zoom conferences or calls uh, a day. Some of us are not as involved, and so having those run see you and hear you has really proven effective. I think that once you get everybody to understand all of the parties involved as to what the issues are and how we're going to resolve them, then the fear of the technology and the concerns about the confidentiality go out the window. And so those I have found that mediations have been very productive. We are seeing an uptick in mediations, and especially as the courts are beginning to reopen. Again, I think India, just like the United States, we're beginning to see another wave of COVID, or maybe we're still in the middle of a second. And so I think it's going to be interesting to see, and probably going to adopt a wait and see approach again. But we are entering into our cold and flu season and our cold time of the winter. And so I think that there's going to be a full shutdown or at least a limited reopening. So again, having procedures in place, technology. I tell my law students this is a really wonderful place for you to start making a name for yourself in this technology. Most older lawyers, and I count myself as an older lawyer, still have a discomfort using technology, using anything they're not familiar with. And so being able to help and guide older attorneys, more experienced attorneys in the technology is a real niche for you. So I think having those skills into the future is going to be very important. So let's talk about arbitration. Why would you pick arbitration over mediation? So again, just to compare and contrast, a mediation is it's voluntary. Nobody is forcing you into making a settlement. You can walk away at any time if you wanted to. In arbitration, there is a decision. There is finality to the process. You again have impartial neutrals. Most of the cases that I arbitrate are sole arbitrators, but typically you can schedule and set how many neutrals you want, how many arbitrators you want. I have been on panels of up to three, in which there were three arbitrators selected, and then you just decide which arbitrator is going to be the lead arbitrator. What having more than one individual does, a couple of downsides is it increases the cost because you have to compensate each arbitrator. It also tends to decrease the length of the arbitration unless the arbitration is set for a particular length of time. Arbitration allows you to present witnesses or exhibits or evidence where in mediation, you're typically only showing to the mediator what you feel supports your position
In arbitration, you're actually having to present witnesses and exhibits in order for that impartial, neutral to make that final decision, that final award. Again, arbitration confidential. You can set the terms of that confidentiality, the parameters of that confidentiality. You also can select that choice of law. So I've had arbitrations that occurred in my state, but we used a different state's law. So your neutral was from one state, familiar, but also the forum would be in one state, but using law of another state. So again, the arbitration can be some choices to give you some alternative methods for litigation. And this is the time where you start thinking, why wouldn't I just want to go to court? Well, at this stage in the United States, you can't get into court. There are no jury trials being held. And so, again, your case has not been resolved. If you've been injured, you're not receiving your payments, your compensation for any medical bills or anything, lost wages, anything like that. So sometimes it's necessary for you to take that case to get it resolved before the courthouse doors open. So what do you decide? How do you decide between mediation and arbitration? Here are some things for you to consider. If you have a contract, your contract typically is going to tell you you have to mediate first, or you have to arbitrate first, or you have to mediate and then arbitrate. Think about what is best for your client. Does your client need finality? Does it need to be done today? Or whatever date you set your ADR for? Is your client one that wants to participate in the outcome?
Or do you think that your client is too
emotional or too angry to sit through the mediation and be productive? Maybe knowing that an arbitration as an alternative is the way to go. What's going to be
practical during this pandemic? So if you have a mediation, are you going to be able to Zoom people in? Are they going to be able to appear via Zoom? How are you going to get discovery? What's the most practical method that's going to cause the least amount of concern health-wise and logistically during the pandemic? What's the best for your case presentation? Do you have really strong witnesses and really strong facts that you know that will make a good impression and help you prove the case before you're independent, neutral? Or do you have some witnesses that are solid, but maybe they're not going to make a really good presentation? Maybe having a mediation where you as counsel are presenting the facts in order to persuade is the best case for your client. And then ultimately, are you going to appear virtually or in person? And that really is, again, going to be dependent upon where you are, the technology available to you, what your client, you feel your client should or can do. Is your client of a high risk? Then of course you're going to do it virtually. But maybe your client is one that, as we say, needs to look the person in the eye, or the mediator needs to look your client in the eye and really have that conversation about this is the likely outcome, and this likely outcome is going to be adverse to your interest. So having all of those considerations in mind when you're making this decision between mediation and arbitration, sometimes you don't have the opportunity to make that decision. The contract may require specifically arbitration only, that there is no room for mediation. Be very mindful also that mediation is not just negotiation. Negotiation is kind of that back and forth between parties about how their case is going to get resolved. Mediation involves that principled settlement discussions where both sides evaluate their position for reasonableness and then work together to achieve a mutually satisfactory resolution of the case. So here was an interesting case that I thought that
in Florida, which at the time this case came out in late July, was a hotbed for COVID. It was a hotspot. And the Florida judge in this case required that the mediation be held in person. So back to that consideration of, are you going to hold your mediation virtually or are you going to hold it in person? The judge made that decision for the attorneys in this case. Again, some concerns in this particular case because everyone was, how are we going to mediate, observing appropriate social distancing? Are we going to hold it outside? How many people can be there? I have held since COVID, I have held several mediations and arbitrations in person, but we had very clear CDC approved guidelines on how many people could be in a room, how long we could be in that room, what type of measures were taken. We are all wearing masks, and then certain types of sanitation before, during, and breaks and such. So keep in mind that your judge may require that you appear in person, and then how are you going to prepare your client for that? I think in this case, one of the things that prompted the judge to do this was the parties kept saying, we're not going to mediate virtually. So again, consider your positions of why you're not going to do it, and so that you can relay that to the judge and develop a workaround. There are a lot of ways. I've held mediations, what I call a hybrid, where I went and I was in the office with the plaintiff's attorney and the plaintiff, the injured party, and the defendant and the defendant's counsel appeared virtually. So that reduced the amount of people in the office. We could socially distance appropriately. We had the appropriate technology and confidentiality concerns in place, and that worked very well. And I think had thing like that been done, this Florida judge would not have made this mandatory. So as we talk about negotiating, when you are in a mediation or an arbitration, you really, as counsel, need to really be working on your negotiation skills. So remember, everything is a negotiation. The fact that you are in a mediation or an arbitration or something else is a negotiation. The fact that you selected a certain individual as your arbitrator or your mediator is a negotiation. So keep all of those things in mind. Remember that not everything has to be argued. So if you don't care, if you feel your case is strong enough, maybe you don't worry about who you choose to be your arbitrator. Not everything has to be an argument. Not everything has to be argued. Now, every step forward gets you to your goal. There is a long, from the time a case begins, from the time the incident happens, to the time you get to have a resolution, which is your goal, every step that you make forward, everything that you do, every concession that you get from your opposing counsel or even your client gets you to where you want to be. Your goal is to have this case resolved in a manner that your client is comfortable with and that is and happy with. So everything that you can do to get to that goal, to get to that successful resolution is important. I think sometimes we feel like too focused on moving forward in big leaps. Sometimes those small steps are really getting in on certain things is a small step forward. So again, making sure that you are focused on what your goal is really is important. Walking away doesn't close the deal. I've seen so many people at a negotiation table, at a mediation, that when things are not going their way, or things are not going the way for their client, both clients and counsel, I'm just leaving. Well,
If you walk away, we all know that that is not going to result in a culmination of a signed agreement. We're not there to sign it. So be mindful, be aware of your ultimate, as we say, drawing a line in the sand. Why are you walking away? Knowing that it's not going to get you any step closer to your goal. Sometimes that's a negotiation trick that some attorneys use. I haven't found it effective. I found it just upsets the other party. Maybe you need to take a break, which is different from walking away from negotiation, from the mediation table. Now, in an arbitration, if you walk away, the case typically will still go on. And you're just not going to have your opportunity to present your case. So keep that in mind. But when you're, especially at a mediation, walking away, think about staying, listening to the other side, leaning in so that you are participating, really goes a long way in getting this resolved. Remember, and I think it's really hard for clients to understand this last concept. Just because you've been wronged doesn't make you right. And what I've seen as a judge and as a prosecutor, as private counsel, and now as a mediator and an arbitrator, is the injured party fails to evaluate their own position. And just because something bad has happened doesn't mean that there's a legal remedy. Doesn't mean that there's going to be funds to make that person whole again. In our civil system, judicial system, we talk about what will make that injured party whole. What will make this right? And sometimes there's just not a way to, in essence, make that person uninjured. So having that conversation with your client, having an understanding, if you are negotiating, if you are mediating with an attorney, a counsel, an advocate who does not understand, who thinks that just because something bad has happened, there is the client has to pay. Have this conversation. Now, again, we move towards what do we do? So the biggest thing is where you are.
how are you going to put all of this into use? Your tactics are very different in 4 topics that we talked about. Pre-suit negotiation, early neutral evaluation are really a first step, dipping your toe into the case. So that's not the time to be very aggressive. It's a time really, again, as I said, this is the time to listen, to learn, and to really lean into what's happening so that you know more about your case, you know more about opposing counsel, You know more about your own client, and you're beginning to learn about how you are going to react to this situation. In an arbitration, it is simply you are presenting the case to the best of your ability to this impartial arbitrator. But in a mediation, this is really your chance to shine as an advocate. It is your chance to think about where's my target? What's my goal? At the end of this mediation, how will I know that it was successful? Does my client have a goal in mind? What's our target? Who is the opponent? Who's the person that is going to be sitting across the table, so to speak, or across the laptop, so to speak, on in your mediation? Is this going to be somebody who is known to be a bully and to have unprincipled negotiation? So if you know that, you can prepare for that. If you know that there's going to be a lot of walking away or gnashing of teeth, so to speak, you can prepare for that. If you have an opponent who you know is going to come to the negotiation table ready to negotiate, ready to mediate and resolve your case, that's wonderful. And you can deal principally and put all of these tools and techniques into place. But if you don't have someone like that, how are you going to persuade him or her to come to your side of the table, to get to this target, to get to this goal your client wants? So again, knowing how to work with others, knowing your case, knowing your client, knowing what small things that you can give up in order to get bigger gains in the end is really persuasion. And at the end of the day, it is always important to know why you're at the mediation table. Why are you arbitrating this case? Why are you involved in any sort of alternative dispute resolution? Most of the time, the why is going to be because it's more efficient, it's better for your client, and you're likely to get the result that you want because you have been able to help negotiate and craft that settlement. So knowing all of these factors is how we can put all of this into action and really utilize these things to make effective and positive outcomes for your client. So I'd like to open it up for some questions.
Ma'am, if I may, how do you do the verification of the documents during an online trial or an online negotiation?
I'm sorry, I think I broke up just a little. How do I do what during my
How do
online?
you verify the documents or the evidences in the online method?
Same way you would do it in a courtroom. So sharing of the screen in an arbitration, if I know beforehand
what documents we're going to use, I have them send me a binder with all the documents, or they email me all the documents. And before they're admitted, we go through. I always like to, and even as a judge, I like to have counsel agree to the documents before we even begin our trial, so that we know which ones are coming in, which ones are going to be a challenge, both for me and for the counsel, and especially for the witnesses. So having being able to share the documents and being able to authenticate them, we typically will do it the same way. So again, you would show the document, you could share your screen, and there have been times that we've set up, if there was a lot, we'll set up a Google Share Drive. Did that answer your question?
Yes, ma'am, definitely, ma'am. Any more questions? Actually, there's some issue with the voice, I think.
Say that one more time.
There's some issue with the voice, I guess. Can you hear me?
I can.
Oh, okay, ma'am.
So what do you think are some of the biggest challenges that the legal system in India
The
has
biggest
faced its COVID?
the biggest challenge is first deciding whether we should go for it or not. Whatever I have come to know, most of them are not yet sure. The Supreme Court of India has started some online platform, but the rest of them are just doing it without any formal guidance or any guidelines. Some are using Google Talk, some are using Zoom. And what is happening is sometimes there is no signal, sometimes the voices crack, and lots of issues are happening. However, in our courts, we are only dealing with the most important cases like the cases with right to life or bail petitions. And most of the other cases, the civil cases, they are still pending. We are yet to open up those. And except the Supreme Court, most of the works are not really, most of the other courts, though they are officially open, they are not into much business now. So it's a big issue, especially with the senior lawyers and many of them who are not very well conversed with the online medium. And the online medium has its own glitches also. So because of which we are lagging much behind. So
How often are you using tools like mediation?
mediation is compulsory in certain cases, like small cases. We have a system called as the Lok Adalat, where like if there is only a fine, where the punishment is a fine or some kind of things, there we use the negotiation. But arbitration is picking up. Arbitration is picking up almost globally, just like everywhere else, especially in the corporate area where we need fast resolution. There we see arbitration a lot. In fact, arbitration has become a very booming field in India. However, the rest in the trials, in the real courts, online medium is still to gain a foothold. Only a few courts have established Zoom or WebEx. WebEx is the most preferred forum. But other than that, the lower courts, they are using whatever they can, whatever they feel like. Okay, let's do in Google Talk, and if they all agree, they are doing it. But only very few cases are being entertained right now by the courts. So it was very interesting knowing the US perspective.
So we've had a few initiatives because in our smaller rural areas, we've had challenges with connectivity and just access to technology. So all of the things that I just talked about don't have any value if you aren't able to connect. And so that has been some challenges, and even pre-COVID, those were challenges because typically the rural areas are the less wealthy, and so there's just this kind of access to justice and racial disparity due to access to technology, and then it prevents the access to the court system.
Does it ever happen that you or the other party do not agree to a particular forum? Like, for example, I'm talking about the online forum. Let's say, like, we don't want to use WebEx, we want this or some kind of issues. Do you have such kind of issues sometimes?
Yes. So I've had where one party wanted to appear in person, one party wanted to appear online because of health concerns. And, again, when I was talking about pick your battles, so to speak, what's the why? Why aren't you agreeing to a particular forum, a particular platform? And if sometimes you have to, kind of talking about that case in Florida with the judge making the in-person mandatory, sometimes I think people were utilizing the issue of COVID to delay the case. So having those concerns, so mediation is mandatory in almost every case in South Carolina. So if you did not mediate, then the judge could strike. There could be some penalties for you towards your case. But again, it goes back to selecting a good mediator that you trust and believe that will guide the process. So what you would do is just have that conversation with counsel. What is truly your concern? Are you concerned about confidentiality, privacy, any technology issues? Are you concerned about what is it that you're concerned about so that we can address it? And I've never not had the issue resolved, and we've never not mediated the case. Somebody may not have been most pleased, but we got the case mediated and resolved.
So I guess online medium is successful.
I find it is successful. And what I do find is as we all become much more comfortable with technology, mediation then has become easier for people to become involved in. And I think it's nice for the individual who has been wronged and even the person that's accused of doing the wrong. They can be in their own home, right? And so that gives them a sense of comfort and familiarity. One of the biggest challenges, I think, for a lot of people that don't participate in the legal system is they're just terrified and they don't understand the process. So if we can sit on our own couch or at our own kitchen table and engage in the process, I do find that does help a lot, right? Instead of sitting in a big conference room or going into a courtroom, letting that person be at home is wonderful.
Do you ever come up across privacy issues or something like that with respect to recording or other things of the proceedings?
So we before I begin any mediation or arbitration, we clearly set out the rules. What confidentiality is, what it isn't, what you can and can't do, who can and can't be there. And so again, there are penalties if any individual would violate. So for example, the settlement in one case was confidential. The injured party was not allowed to talk about it. And of course, he had gone home and discussed it, and his daughter heard. And she posted on Facebook the nature of the settlement. So, of course, the company found out because it was public, and they withdrew the settlement and because he violated the terms of the agreement. So we talk about that, and a lot of times to make it very simple, because that's an issue that everybody can understand. I mean, we've all seen things on Facebook, or we put things on Facebook before we really think about them. And so that's a really close to home explanation of what you can and can't say. And how important confidentiality is. So yes, we have that. I indicate what I may do is record only them agreeing not to record. And so that I can use that if anything ever happens and we have to take that in front of the presiding judge where they would say, everybody agreed and they violated this rule of confidentiality. So that's a, again, having a clear understanding of your forum, why you're there, who you're there with. Some counsel I know, they're not, they are the salt of the earth, so to speak, and they would not do anything inappropriate. Some counsel I know that they're going to push the rules to the limit every time. But mainly I have that conversation for the benefit of the parties so that they do understand there are consequences if you don't follow these rules. So would you like me to, I just saw that question pop up in the chat tool. Would you like me
Yes,
to
yes,
answer
ma'am.
that question?
Definitely, ma'am.
All right. So the question is, and thank you for your wonderful compliment, negotiation. Can you give an idea about negotiation in corporate world, respect contract execution? What are the key areas we need to focus on while negotiating? So, and if I understand kind of a couple of parts to your question, negotiating in the corporate world, and so the beginning of the contract process, is that what I understand it to be, Trishna?
Yeah, yes, ma'am. It's the beginning of the contract execution process. It's a kind of contract lifecycle management process.
So again, I think all of those principles that I talked about, knowing where you are. So you are negotiating a contract for a particular process or a particular item, knowing why you're there to negotiate, knowing who you're negotiating, and really stepping back from the process and saying, why am I even negotiating this contract? Making sure that you're negotiating with ethically and responsibly and principally will get you very far. And knowing what you need to negotiate, knowing the law, again, that goes without saying. So knowing the concepts that you need to articulate. Now, there's lots and lots, and we could spend hours talking about the art of negotiation. I just hit some highlights for that. But again, so if you wanted a particular item in a contract, then know why you want that item. Know, are you willing to give anything else up? And so, and I hope that I'm answering your question. So the key areas to focus on while negotiating is, again, maintaining your understanding of what you're willing to give up and what your end goal is. Listening to the alternate proposition is important as well, so that you know where you're coming from. I think what happens a lot of times when we're negotiating contracts is we just don't understand what's happening or where the other person is coming from. We take that person to just be adverse to all of our interests. Trishna, I hope that answered or addressed some of your questions. And
Definitely.
I'm going to put my email in. If you wanted to follow up with me, feel free to do so.
Sure.
Thank you.
Any more questions and queries for our speaker?
And feel free, please email me if you have any particular questions. I am happy to discuss any concept with alternative dispute resolution, especially as with respect to training and how you could go about that. Happy to have those discussions with you. This was just an overview of some of the challenges that we've faced and how we have addressed some of those challenges. But again, I'm happy to come back and talk about a particular topic more in depth if you would like. You know, particularly on how to, once you're at the table, once you're at the mediation table, how you can move forward to get what you want for your clients. Right.
Thank you so much, ma'am. So I think I will conclude the session today. In the end, I thank our speaker, former Judge Miss Kristi Harrington, arbitrator and negotiator and adjunct professor, for taking out some time for us. Her insight as a judge and a mediator and an arbitrator is definitely helped us. I thank our college, our principal, Dr. Bhupesh Bujar Borua, my colleagues, and the staff of BRM Government Law College for giving me this opportunity to organize this lecture. And in the end, I again thank our speaker for taking out for some time for us. And with that, I conclude this thing. Thank you, ma'am.
Thank you so much.
So we conclude here, ma'am.